It's my, we're having a little trouble with the air conditioner. It's not too cool in here, but. Matt? What? It's a policeman.
So go ahead and put your hands behind your back for me, okay?
Can't put on pants or anything?
You got shorts on.
I ain't got no underwear on.
That's alright.
Oh, shit.
Okay.
No, hell no, I ain't getting in trouble.
This body camera footage was recorded on June 17, 2024, at a private residence. The interaction concluded with an arrest for burglary to a motor vehicle. Before the handcuffs went on, this suspect had one unusual request: pants. That small moment reveals a bigger question about how far officers should go to secure cooperation.
Hi, ma'am. I'm off Swirl Flow. I need to talk to Matthew, please.
Sure.
Thank you.
Matt? Can you come in?
Thank you.
It's my, we're having a little trouble with the air conditioner. It's not too cool in here, but. Matt? What? It's a policeman.
He's back here.
Yeah, he'll come in. They were playing in the water.
Playing in the water?
Clothes on.
Okay. Him and Amy?
Mm-hmm.
Well,
Hi, Matthew. I'm Officer Wolf. You want to step out and talk to me for a minute? Hi. All right, Matthew. Before I ask you any questions, I want to read your rights to you real quick, okay? You know why I'm here?
no, me and Amy just got back.
Okay. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Your right to talk to a lawyer and have your lawyer present with you while you are being questioned. You can afford to hire a lawyer upon request, but won't be appointed to represent you before any questioning. You can decide at any time to exercise these rights and not answer any questions or make any statements. You understand that?
Yeah.
Okay.
The first legal issue is timing. Rights were read only after the suspect stepped outside for questioning. Under Miranda versus Arizona, warnings are required once a reasonable person would not feel free to leave. Here, casual conversation happened first, and rights followed only when substantive questioning began. That sequencing was correct, but it depended entirely on the officer's judgment call in the moment.
Where all you been at today, Matt?
Doctor's office and the creek.
Doctor's office in the creek? What doctor's office?
One by the hospital.
Okay. What were you doing at the doctor's office?
I had an appointment, and then she had an appointment.
Okay. What'd you do when you went to her appointment?
I went in for a little while, came outside.
Before you answer, just know that there's surveillance footage all outside the hospital, okay?
Yeah.
I just don't want you to get caught up on nothing.
Yeah, Jim Martinez is my sister's ex.
Mm-hmm.
And I was just seeing if that was his truck or not.
Okay. You got in the truck?
I looked.
Open the door?
Looked.
Okay. Did you retrieve anything from inside the car?
No.
You sure?
Yeah.
Did you go through paperwork inside the car? Didn't touch anything?
No, not at all.
Okay.
I just opened the door and looked to see if that was him or not.
Okay.
So I used to live with him, right beside him and everything.
Okay. All right. Well, we've got you on surveillance footage entering the car. We have a separate witness saying you exited the car with an item out of the car.
No.
That's what he's saying. And
No.
our victim, Mr. Otacuna, says he's missing property.
Oh, shit.
Okay.
No, hell no, I ain't getting in trouble like that.
You were wearing a blue Reebok shirt earlier when you were there?
Yes.
Okay. All right, sir. Well, you're going to be placed under arrest for burglary to motor vehicle today, okay?
All right.
So go ahead and put your hands behind your back for me, okay?
Can't put on pants or anything?
You got shorts
I
on.
ain't got no underwear on.
That's all right. You're going to be taken to jail, booked. You ain't got any medical problems that needs cuffed in the front, do you?
No.
Okay.
If you want to help yourself out, man, and just like return what was taken from that vehicle, that would do you a great deal of wonder here.
So do you want to retrieve that property before I put this other cuff on?
The second issue is probable cause, built from 3 separate pieces of evidence. Surveillance footage placed the suspect at the vehicle, a witness saw him leave with an item, and the owner reported property missing. Under Illinois versus Gates, courts look at the totality of these circumstances, not any single piece alone. None of the three pieces alone proves guilt, but together, they clear the bar for a lawful arrest. There's also a timing wrinkle in the arrest itself. Probable cause existed before the suspect ever opened the door. That matters because once probable cause exists, further voluntary statements are bonus evidence, not requirements. The fourth issue sits in a gray area. An offer to help yourself out by returning the item. That phrasing edges close to implying a lighter outcome, a decision that belongs to prosecutors, not officers. Framed only around handcuff placement, that offer would be fine. Framed around consequences, it is not.
Yeah.
Okay. Thank you. I appreciate that.
Make things a little lot easier for you. It shows that you effed up, but then you were cooperative. About the best we can do for you in this situation, so we appreciate that.
And if you give me that, I'll let you put some underwear on. Cool?
Well, I don't want to say nothing until, they'll give us a shot. Back in here?
You ain't got no weapons in here you're gonna grab, are you? No? Okay. That's it?
That's it.
Any medication?
No.
What's that?
No, sir.
Okay.
All my medication is either in the living room.
Oh, we just needed to talk.
You didn't take any hydros or nothing like that?
No, no.
Okay.
You can look at all my in my drawers, or you can look at everything.
Okay. Any reason why this?
No.
Just cause?
It's just stupid.
Okay.
'Cause they're fighting.
Okay. I'll let you. You ain't got no weapons in here. If I turn around, you're not gonna
No, sir.
grab any weapons. Okay. I'll let you put that on real quick, okay?
I found her.
It's just good to live your life that you're always being recorded. It's just good advice.
Yeah, man.
Oh, here's my medicine right here.
Okay. Yeah, that's fine. Step on outside, sir. I appreciate your cooperation.
Oh, God.
All right, man. Since you work with me, I'm gonna work with you. I'll just cuff you in the front. Be a little bit more comfortable. Okay. Here's what I'll do for you. I'm gonna take you to jail. Okay. They're gonna take your picture, probably fingerprint you, and then you'll be released with the court date. Okay. That way you ain't gotta sit in there. Fair enough?
Yes.
Okay.
The third issue is consent, and it is far less clear-cut. The officer asked about weapons and medication inside the home, and a family member allowed him in. Under Schneckloth versus Bustamante, consent must be voluntary, not simply assumed from politeness. Nothing on this recording confirms the family understood they could refuse that request. Grading the officer A/B+ for lawful procedure paired with one risky phrase. Miranda timing was correct, probable cause was solid, but the leniency adjacent language needed tighter boundaries. Grading the suspect A/B- for cooperation that came only after being confronted with evidence. He waived his right to silence early, then gave an account that surveillance footage later contradicted.
All right, we're gonna head to this car right behind you. Okay. City 119. I got that mail 95. You don't want any slides or anything on?
No.
Okay. All right. We'll go to the passenger side.
Don't worry about it, Mom.
I'll be back soon.
Passenger side. I gotta unlock it for you, and then I'm gonna crank up the AC as best as I can for you. Have a seat for me. Have a seat for me. City 119, if you just notify the jail, I'll be transporting this mail shortly. Can you feel that air? Okay, all right. City 119. If you would, notate Miranda on scene, B76 Druce County.
A third party matters here too, the witness who saw the item leave the vehicle. That witness statement did more legal work than the officer's own observations, anchoring the probable cause finding. So if the evidence had rested on the officer's word alone, would this arrest have held up? First, once you're a specific suspect, remember that voluntary statements can still lock in the case against you. Second, consent to a search is a right you can decline, even when an officer asks politely. Third, comments about lighter treatment for cooperation should raise a flag, since only prosecutors decide charges. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe for more analysis of police and court interactions.